There is a legal structure so elegant in its design that Wall Street attorneys charge between $15,000 and $50,000 to set it up for their clients. And yet, the filing fee in the states that offer it can be as low as a few $100s. It allows you to own an unlimited number of separate legal entities, each completely isolated from the others, each holding its own assets, each carrying its own liabilities, and each protected from the legal problems of every other entity in the family, all under a single umbrella that files one tax return, maintains one registered agent, and costs a fraction of what it would take to maintain the same number of fully independent companies. If a lawsuit hits one of the inner entities, the assets of every other inner entity are untouchable, not harder to reach, not subject to additional legal process. Untouchable. Because the law treats each inner entity as a separate legal person with no connection to its siblings. This structure is called the Series LLC, and it has been legal in Delaware since 1996, in Illinois since 2005, in Texas since 2009, and in a growing list of states that have recognized it as one of the most powerful asset protection tools in American commercial law. The concept was originally developed for the mutual fund industry, where fund managers needed to create multiple investment pools under one management umbrella without the liabilities of one pool contaminating the assets of another. It was then adopted by real estate investors, family offices, and high net worth individuals who understood that the same architecture that protected billion-dollar investment funds could protect a rental property portfolio. Wall Street had it. Real estate attorneys knew about it, and virtually no one who actually needed it had ever heard of it. Welcome to the Invisible Ledger. If these stories matter to you, hit subscribe and the bell. This is where we trace the money they told you not to follow. To understand the Series LLC, you first need to understand the problem it solves. Suppose you own 5 rental properties. Each property is a separate asset with its own risk profile. A tenant at property 1 slips and falls and sues you for $500,000. If all 5 properties are owned in your personal name, all 5 are exposed. If all 5 properties are owned by a single LLC, the lawsuit against the LLC can potentially reach all 5 properties within it. The traditional solution is to create 5 separate LLCs, one for each property. This provides clean separation. A lawsuit against the LLC holding property 1 cannot reach the other 4 LLCs, but 5 separate LLCs means 5 sets of formation fees, 5 annual state filing fees, 5 registered agent fees, 5 operating agreements, and potentially 5 separate tax returns depending on how they are structured. The Series LLC solves this problem by creating a master LLC called the umbrella or parent series, under which an unlimited number of separate series called cells or pods can exist. Each series can hold its own assets, have its own members, carry its own liabilities, and maintain its own records. And in states with proper Series LLC statutes, the liabilities of one series are enforceable only against the assets of that series. The assets of other series within the same umbrella are explicitly protected by statute. The Delaware Series LLC was established under Delaware Code Title VI, Section 18.215, first enacted in 1996. Delaware, which is home to more corporations and LLCs than any other state, and which handles more commercial litigation than any other court system, designed the provision specifically for the investment fund context, but wrote the statute broadly enough to accommodate any business use. The Illinois Limited Liability Company Act introduced Series LLCs in 2005 under 805 ILCS 180-3740. Texas followed under the Texas Business Organizations Code, Section 101, 601. Nevada, Wyoming, Utah, Tennessee, Iowa, and a growing list of states have since enacted their own Series LLC statutes. As of 2024, over 20 states permit some form of Series LLC formation. The critical statutory language that makes the structure work is the liability shield between series. In the Delaware statute, the language states that the debts, obligations, and liabilities of a series, whether arising in contract, tort, or otherwise, shall be enforceable against the assets of such series only, and shall not be enforceable against the assets of the limited liability company or of any other series thereof. This is not a general asset protection principle, subject to interpretation. It is a specific statutory command. The liability is confined to the series, period. Before I go further, this video is just the surface. Inside the Invisible Ledger Vault, you will find the complete Series LLC formation guide for Delaware, Texas, Wyoming, and Illinois, the inter-series operating agreement templates, the asset segregation checklist required to maintain the liability shield, state-by-state statute comparison, and the real estate investor's guide to structuring a property portfolio inside a Series LLC. The link is in the description. But stay right here. The family office community has been using this structure for over 2 decades. A family with 10 investment properties, 3 business interests, And a stock portfolio can create a master series LLC with 13 separate cells. Cell 1 through 10 hold the 10 properties. Cell 11 holds the operating business interests. Cell 12 holds the investment portfolio. Cell 13 holds cash and liquid reserves. Each cell is insulated from every other. A slip and fall at property 3 reaches cell 3 and stops. A business dispute in cell 11 cannot reach the real estate in cells 1 through 10. The entire structure files a single consolidated tax return, maintains a single registered agent, and can be managed by a single administrative framework. The structure also offers extraordinary flexibility for bringing in outside investors or partners. Each series can have its own membership interests with different economic terms. An investor who wants to participate in property 7 but not the others can be admitted as a member of cell 7 only with no legal connection to any other series. This allows family offices and investment groups to create joint venture structures within a single entity umbrella, something that previously required multiple standalone LLCs with complex cross-entity agreements. If you have made it this far, you already understand the Series LLC at a level that most real estate investors and small business owners never reach. Subscribe and share this video. The structure has limitations that are important to understand. The primary uncertainty is interstate recognition. A Series LLC formed in Delaware is governed by Delaware law within Delaware. But if you own a property in California and that property is held in a Delaware Series LLC, California courts may not recognize the inter-series liability shield because California does not have its own Series LLC statute and has not officially recognized the liability separation principle for foreign series. This is the most significant unresolved legal risk in Series LLC planning. Real property should ideally be held in a series formed or registered in the state where the property is located, or in a state whose statute has been explicitly recognized by the jurisdiction where the property sits. The second significant requirement is meticulous record keeping. The liability shield between series is only as strong as the separation between them. Each series must maintain its own bank account, its own financial records, its own set of operating decisions, and its own documentation of assets. If assets and funds are commingled across series, a court could find that the series are not genuinely separate and pierce the inter-series liability shield. The discipline required to maintain the separation is identical to the discipline required to prevent corporate veil piercing in a traditional LLC structure. Now let me give you the practical steps. Step 1, choose your formation state. If you own property in Delaware, Texas, Wyoming, Illinois, or another state with a Series LLC statute, form in your state. If you own property in a state without a statute, consult with an attorney about the risk profile of using a foreign series structure versus a traditional multi-LLC approach. Step 2, file the Master LLC Articles of Organization with the appropriate state agency. The articles must indicate that the LLC is organized as a Series LLC and that the liability limitation between series is intended to apply. Step 3, create a comprehensive operating agreement for the Master LLC that establishes the series framework, defines how new series are created, and specifies the governance, economic, and liability rules for each series. Step 4, create designation documents for each individual series. In most states, series are created by a notice of designation or a series designation filed internally rather than with the state, though Texas requires a public certificate of formation for each series. Step 5, open a separate bank account for each series. Every financial transaction involving a particular asset must flow through this bank account of the series that holds that asset. Step 6, transfer assets into their respective series using appropriate conveyance documents, deeds for real property, assignment agreements for business interests, and account transfers for financial assets. Total cost of formation. State filing fees ranging from a few $100s for the Master LLC, plus legal fees for the operating agreement, and series designation documents ranging from $1,000 to $5,000, depending on complexity. Compare this to the cost of 5, 10, or 20 separate LLCs, each with their own formation costs, annual fees, and administrative burden. I need to be honest with you. The Series LLC is powerful but not universally recognized and not without real risks. First, federal bankruptcy courts have not uniformly recognized the inter-series liability shield. Some bankruptcy trustees have taken the position that all series of an LLC are part of a single bankruptcy estate. The law here is still developing. Second, the IRS has not issued definitive guidance on how each series is treated for federal tax purposes. Most practitioners treat each series as a separate disregarded entity, but the IRS could take a different position in a future ruling. Third, as noted, interstate recognition is the biggest practical risk. A series shield that works perfectly in Delaware may be ignored by a California court. Fourth, the structure requires ongoing administrative discipline. Commingling funds between series, even inadvertently, can destroy the inter-series protection. Fifth, the Series LLC is a relatively young legal structure, and there is limited case law in most states interpreting how the shields hold up under real litigation pressure. The statutory protection is clear, but untested shields carry uncertainty. Your grandparents, who ran family businesses, understood intuitively that you never put all your eggs in one basket. For generations, family enterprises were naturally divided. One building owned here, one business run there, one field in one name, another in a different one. The division was not elegant or systematic, it was instinctive. Then, one generation consolidated everything into single entities, single accounts, single tax identification numbers, because simplicity was convenient and the legal exposure was not yet visible. The Series LLC is the modern, systematic version of the oldest financial wisdom in human commerce. Separate what can be lost from what must be kept. There was not a more sophisticated system, there was just a more structured one. Subscribe and share this video. Every share puts the Series LLC architecture in the hands of someone who is currently holding multiple assets under a single legal roof that a single lawsuit could collapse. The next vault opens soon, and what is inside will reveal why the wealthiest people in America have not used a debit card in decades, and exactly what law makes their credit card a financial weapon. These